Hello, this is The Scale of Justice, that program that reaches you from all the channels of the Nigerian Television Authority with the happenings in our justice sector, all with the aim of enhancing the rule of law in Nigeria. I am Femi Okewo with the pleasure of having you around on this edition. In our last edition of The Scale, I hinted that we are getting to the time of the year where we do a lot of stock taking from all the arms of our courts in Nigeria. Yes, it is that season which they call the new legal year. And the Court of Appeal has opened the door for stock taking as the president of the Court of Appeal conducted the affairs of the new legal year of the Court of Appeal. Now the Court of Appeal has gone so wide in Nigeria now, it has divisions all across the country. And so it's necessary to know what that court is doing. And indeed, it is a court that is next to the Supreme Court. A lot of issues are determined at that level. Now, we're going to bring you the happenings that opened up the new legal year for the Court of Appeal. And Austin Ayebe is our guide in that segment.
The 2022-2023 legal year event no doubt provided key players in the justice sector at the Court of Appeal the opportunity to take stock on how it performed in preceding year. Given his assessment, the Attorney General of the Federation and Minister of Justice says the court has performed creditably, but much is expected as the electorate move to the polls to elect new leaders.
The Court of Appeal of Nigeria has indeed come a long way over 45 years period during which it has established itself as a major determinant of the course and development of our jurisprudence. Aside serving as a penultimate court in our judicial architecture, the 1999 Constitution as amended, Section 239 and 285 thereof, has conferred the Court of Appeal with enormous responsibilities in ensuring the sanctity of our electoral process and strengthening our democratic process and practices as well. As we approach the 2023 elections, your lordships will be called often again to adjudicate often election petition matters. I commend the foresight of His Lordship, the President of the Court of Appeal, in taking proactive steps towards an effective discharge of the onerous constitutional mandate over the outcome of elections. These notable steps include engagement with relevant stakeholders, especially with the advent of the 2022 Electoral Act. I am also gladdened that His Lordship has inaugurated a 13-man electoral judicial manual committee that will also see to the issuance of the maiden election edition of the Electoral Judicial Manual, which will provide an operational framework and reference guide for the determination of election petitions.
On several challenging issues bedeviling the judiciary, such as complaints about poor remuneration and allowances, as well as enhancement of our ICT facilities, the Chief Law Officer said government is working towards addressing them.
The available indices clearly shows that the current administration, under the leadership of President Muhammadu Buhari, has demonstrated the much-needed political will in key areas aimed at advancing the separation of powers, independence of the judiciary, and indeed the funding of the judiciary and strengthening the capacity of our courts in the exercise of their judicial powers. I earlier made reference to the issue of welfare package of judicial officers. I need to emphasize that the comprehensive welfare package being proposed is a product of collaboration between the judiciary and the executive, and it will cover vital areas such as salaries and allowances, housing, health, professional development, as well as enactment of a separate legislation to give legal framework to the foregoing. As you may recall, in June 2018, President Buhari granted his assent to the Constitution of the Federal Republic of Nigeria Ports Alteration Number 4 Bill. This alteration brought about and indeed granted financial autonomy to the state houses of assembly and state judiciaries. In view of low level of compliance with the provision by the states and in furtherance of the need to create enabling environment for financial autonomy to thrive, President Buhari issued Executive Order Number 10 on 20th May 2022. However, this noble policy was shut down by the relentless opposition of the state governors. The appropriate constitutional enablement having been provided, it is expected that relevant stakeholders will take up the government.
Other speakers, while commending the President of the Court of Appeal for her quality leadership, seek collaboration and support for the judiciary as Nigerians expect so much from the organ of government.
Legal practitioners must be conscious of the rules of the profession, of the professional conduct, and shun all unethical, corrupt, and insidious practices that can bring disrepute to our noble profession. I wish to acknowledge the support and reassurance of my Lord, the Honorable, the Acting Chief Justice of Nigeria, my Lord Justice Olukayode Arinola, in ensuring a formidable court and judiciary. The cooperation of all the heads of court of the Federation, the Federal High Court, National Industrial Court, the High Court of the Federal Capital Territory, the Sharia Court of Appeal, the Customary Court of Appeal, at all times contribute immensely to the progress we have recorded, especially with our special panels.
Many of you judges are killing yourselves in your efforts at meeting unrealistic deadlines imposed on you by the system. In the end, you can only become inefficient and bring yourselves under unjust suspicion. The judiciary is founded on the premise that the work of the judges will be limited. If that limit is exceeded, there is nothing that judges can do. They can only become indifferent. The judiciary needs all the support and encouragement we can give her. Our duty in that regard is unqualified. This is no time to proclaim the weaknesses of the judiciary. After decades of neglect, the judiciary is struggling to find her feet. Our duty is to aid and facilitate her recovery. We should not continue to heap temptations on the judges and disparage them when some of them fall. It is we who tempt the judges. It is we who blame them when some of them fall.
That now more than ever, the people of Nigeria look up to the legal profession, the bench and the bar, for the recovery, reformation, and repositioning of this nation, which they understand can only happen through a deliberate pursuit of justice and must be led by the legal profession. In this regard, the existence of a strong and independent judiciary is critical in the attainment of that state of affairs, where justice will not only be present, but also be seen to be present.
The ceremony heralds the beginning of new legal activities at the court in Abuja. Austin Anyebe.
Earlier in the year, I had done an interview with the president of the Court of Appeal. We're going to use this segment to reflect again on some of the issues that are still being worked on, either by the administration of the Court of Appeal or the judiciary generally in Nigeria. And so we give you a playback of some parts of the interview I had with Justice Monica Dongban-Mensing, the president of the Court of Appeal. What does this fellowship mean to you as a person?
Well, as a person, I think it's an exceptional honor to me, to be conferred with the fellowship of an institution that is meant to, that has been set up to develop the legal profession, And as a jurist, our work is about research, reading, writing, and developing the law. So I find this conferment as a challenge, an invitation to harder work, to look deeper into the law, and to find out how, we can use research findings to develop the law, and for me to, to heal some of the ills of practice in adjudication, if you understand what I mean.
Yes. Yes, you're already moving into the next area where I want to ask. The Court of Appeal must also feel honored that its president has been so honored. How do you think the Court of Appeal will benefit from this honor that has been done to you?
Well, I think the Court of Appeal most certainly stands to benefit to the extent that when we have, worrisome issues, we know that we can refer it to the institute, and they will carry out research, since that is their, area, to find out solutions for us, and map out the way forward, to avoid some of the loopholes that create, some negative issues that seem to be recurring, with our work in adjudication. Mm-hmm.
Now, years ago, Nigerians used to hear of contradictory judgments emanating from the Court of Appeal. How have you been able to stem the ones that used to come from the Court of Appeal?
Well, the issue of conflicting decisions have actually been, blown out of proportion. You see, as a Court of Appeal, we sit in 20 different divisions, and there's hardly any case that is exactly the same. So the likelihood of variations here and there, in decisions emanating from our different divisions shouldn't really be a big deal. However, how I have approached the issue of, conflicting decisions is to ensure that
we watch out for each other. You know, the justices were on the same page. We try to see if a decision has been given, like, you know, all these controversial cases, political matters, commercial matters, or whatever. If we know that it's in an area of likely conflict, we share whatever decision has come up, and we try to discuss it. We have a platform now, thank God, to, you know, ICT and all that, and you know, so it's a continuing process. We just keep alert. If any decision, you know, comes up, we try and ensure that every justice of the court is, you know, put on notice about the existence of this decision. And if you look at our diaries now for this year, we have on each page, or at least on the birthdays of each of the justices, of the 89 justices that we have, 88 justices that we have, their pronouncement is published on their birthday. So it will put every justice on notice that the Court of Appeal has made a pronouncement on this subject. So beware. If you have a similar matter before you, make sure you read that decision so that you'll be properly guided. And then, you know, if the Supreme Court has made a pronouncement about our decision, we try to bring it to the notice of all the other justices so that we'll be properly guided.
Imagine any society without laws. Imagine piles of laws without the courts to interpret them. Imagine lots of interpretation without a medium to bring them to your doorsteps. The scale on the network service of the Nigerian Television Authority helps to fill the gaps and turns law and justice into a tangible instrument for national development. That is the scale, and it is balance.
And now we go to human rights affairs. The Governing Council of the National Human Rights Commission in Nigeria has put together some documents which should help promote and enforce the compliance to human rights activities in Nigeria. And of course, in order to make these documents implementable, some of these documents must be passed to the National Executive Council. And so the Governing Council of the National Human Rights Commission visited the Attorney General of the Federation and the Minister of Justice to put forward these documents as a first step to getting them approved by the National Executive Council. Of course, it is also an advocacy visit and a partnership visit by the Governing Council of the National Human Rights Commission, and to see how some of the legislations pending at the National Assembly can be quickly activated and signed into law when passed by the National Assembly. And so let's take a brief story on the visit of the Governing Council of the National Human Rights Commission as they visit the Minister of Justice and Attorney General of the Federation.
In recent times, issues of promotion and protection of human rights in Nigeria has been a source of concern to many. To address some of the encumbrances, these board members of the National Human Rights Commission is seeking more collaboration of the Ministry of Justice.
Attorney General, that will be presented before you today include the following: asking that the federal government will make the requisite declaration pursuant to Article 34 of the Protocol to the African Charter on Human and People's Rights, as doing this will create direct access to the African Court on Human Rights by individuals and non-governmental organizations. This singular move will widen the scope of access to protection of human rights in the continent of Africa and Nigeria in particular. Secondly, we'll be seeking the ratification of a protocol to the African Charter on Human and People's Rights, on the rights of older persons in Africa, a subject which I believe you are very committed to.
Looking at it from the perspectives of enactments that are indeed deliberately targeted at supporting the human rights posture of the government, I think we have equally done wonderfully well. Among the antecedents establishing our commitment to human rights was the importation by way of law and legislation of the protocol, African Charter on Human and People's Rights Protocol to Nigeria. We have consolidated further on that by way of establishing deliberate legislations, inclusive of legislations that are targeted at supporting the rights of persons with disabilities in Nigeria, among others. This is a government that has a history, a tradition of respect for human rights, both in terms of having legislative framework, supporting it with institutional framework, and further reinforcing same with observance and enforcement of your decisions where they are handed down. So with that in mind, if you are coming up with a proposal relating to National Action Plan, among others, and indeed federal executive support of national policy for the protection of civilians from harm, it is indeed something that the government will very much welcome against the background. The government will certainly welcome it against the background of consolidation of what we have been doing as it relates to the human rights observance as a country. This is a government that has established a compassionate approach to governance, compassionate within the context of not only having legislative framework, but indeed having institutional framework and supporting them with giving effect to decisions that are mostly compassionate in their undertones and outlook.
The collaboration between the board members of the National Human Rights Commission and the Ministry of Justice will assist in promoting human rights in line with international best practices. In Abuja, Umeka Marchku.
Those are the issues we have slated for you this week. More issues, of course, keep cropping up day by day in the justice sector of Nigeria, and you can always trust that the skill will be there to get them to you. We'll see you again in another edition.